All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So I'm going to talk about one topic very, very briefly today, and then I'm going to do a little bit deeper dive than Tom did last week on the DOL's new overtime rule. The first I wanted to talk about and just mention, and we'll probably do a deeper dive on this in one of the upcoming programs, Phil, is that the EEOC, as I've mentioned before on the program, was in the process of updating its harassment guidance. The EEOC on April 29th, just a few days ago, did finalize its new harassment guidance. It's the first update to its harassment guidance in a quarter century. And it really does kind of give the document greater relevance in today's workplace, as well as chances of additional lawsuits to challenge this new harassment guidance. This guidance, like I said, that was issued on April 29th, reinforces LGBTQ plus employee rights, like allowing the use of bathrooms that fit a worker's gender identity and protection from misgendering, in addition to outlining how employers can tackle harassment that occurs in the virtual workplace and through social media. Just want to mention that this is really the EEO's second attempt to update its harassment guidance. They tried in 2017 and that failed. And so the harassment guidance hasn't been updated since 1999. So just want to mention that. Like I said, I think at some point it probably makes sense, maybe next week or the following week, to do a deeper dive into what that harassment guidance, the updates mean for employers, like I'm going to do as I transition over to the DOL guidance that was released, or the final rule that was released last week. How about that, Phil?
All right, hey, you go get some practice and then you bring it back here for perfection, okay?
Perfect. That's what I always try to do.
And for all of our listeners, it's not guidance on harassment, it's guidance not to harass, what we cannot, should not, and will not do.
Yeah, sure, Phil, that's right.
Right, okay, so, very good.
All right, so let's, I know, like I said, Tom Chibnall from my firm last week mentioned about the new overtime rule it went into effect, the final rule on April 23, 2024, or that was the day it was issued. It's not in effect yet. And I know, Phil, I've been getting a ton of questions about it. My firm has, I know you guys at AIM have. Yep. And so you and I thought it would make a sense to do a little bit deeper dive. So the department on April 23rd did issue its highly anticipated final rule to really change substantially the minimum salary threshold and highly compensated employee threshold under the Fair Labor Standards Act. The important pieces are that on July 1 of this year, so just 2 months away, the minimum salary threshold is going to go up by 23.4% over the current threshold. And then on January 1, 2025, another increase is set to take place, resulting in a 64.9% increase over the present day. The Department of Labor has estimated that the change to the overtime rules could impact up to 4 million employees. So that's pretty substantial. The highly compensated threshold is going to increase from $107,432 to $132,964 on July 1, and then to $151,164 on January 1 of 2025. And then, very importantly, the final rule also implements a virtually automatic update to each threshold that will occur every 3 years beginning on July 1, 2027. So, like I said, some very significant changes. And I think to sort of appreciate the changes, it's worth kind of talking just a little bit about the history of all of this. Of course, the Fair Labor Standards Act sets the rules that determine if an employee is eligible to receive overtime if they're non-exempt, or not required to receive overtime if they're exempt. And the salary thresholds set by the FLSA are really the minimum salary amounts at which point a covered employee becomes exempt from receiving overtime. So right now, what we look at is, in order to classify someone as exempt, the employees really have to pass 3 tests. They have to be paid on a salary or fee basis. The salary or fee basis must exceed the minimum, which currently is $684 per week. I'm going to talk about that in a second, the changes. And then 3, a job duties test. And so I want to point out one very significant thing. This new rule, the new final rule, does not change the job duties test. So the job duties test that we've been looking at for exemptions under the executive, administrative, professional, and outside sales and computer employees, those duties tests are not changing at all. What is changing is the salary or fee basis that, like I said, the minimum is currently $684 per week. And what those changes exactly are is that the changes are going from $684 a week to $1,128 per week, or the equivalent of 58,656 by January 1, 2024. Now, I also mentioned 2025. I also mentioned that there is that interim step, though, where the salary basis is going up to on July 1 of this year, so just 2 months away, to an interim amount of $47,476, or about $46,000. And so that is going to be a very significant change. There is that interim step in there that we need to be mindful of. So talking about the history of it, the minimum salary for exempt staff was updated all the way back in 2004 and was set at $455 per week, or $23,660 per year. That remained unchanged all the way up until 2016, when President Obama, his Department of Labor, doubled the minimum salary for exempt staff to $913 per week, or $47,476 per year. So that rule in 2016, though, it never went into effect because there were strong challenges to that, and a federal judge stopped that proposed threshold taking place just days before its December 1, 2016 effective date. So then in 2019, the Department of Labor announced a new rule for January 1, 2020, and that set the minimum salary at the current $684 per week, or $35,568 per year. That went into effect on January 1, 2020. And so again, this marks the first time since January 1, 2020, when the salary threshold has been adjusted. I do expect legal challenges to this. It's going to be really interesting to see what happens, because basically the rule, by taking this two-step approach under this current rule, by doing this interim increase in July, that jumps it up to, I gave you the wrong number before, that jumps it up to 43,888. By taking that two-step process, July 1 and then January 1 of next year, the July 1 increase really follows the methodology that the Trump administration used in the 2019 overtime regulation, which went into effect on January 1, 2020. And there were no legal challenges to that. That one did go into effect. And so this new rule under the Biden DOL looks a lot like that for the July 1 increase. Now, the January 1, 2025 increase looks a little bit different. And that's where I expect to see the legal challenges take place. And so we'll have to see what shakes out with that. There are business groups who are talking about suing. What'll be interesting to me is my gut tells me, here's my prediction, my crystal ball for you, Phil. My gut tells me that the increase for July 1 is going to go into effect. And so that means employers need to really start looking right now at their classifications of employees. And then I do think the legal challenges will work their way through. And I'm not quite sure, I'm not as confident that the January 1, 2025 portion of the rule will actually go into effect.
Just based on the fact that it's too much too quick?
Well, it also contains some mechanisms that look a lot more like the Obama rule for adjusting the increases over time. The rule that was challenged in 2016 and was stopped by the court. So I do think that there's a chance that that portion of it gets struck down.
Okay, very good. Hey, Burt, just a couple questions before you go. And I know you're in a little bit of a time crunch here. Yeah. One of the common questions I get is, well, this person's title is a manager. They don't really manage any people, but they manage, they're a manager.
They manage work.
They manage work, but they're they're below the threshold. What am I okay because they're a manager? That's a very common question. And I think that answer is no, but can you just talk about that for a minute?
Yeah, of course. That is a common question. And so, they have to meet those 3 tests that I gave you before. They have to be paid on a salary basis.
Mm-hmm.
They have to be paid at least the minimum threshold, which is currently $684, but it's going up significantly under the new rule. And then they have to meet the duties test. And so, like I said, this new rule is not changing the duties test, but just because someone is called a manager and they manage work, it does not mean that they actually are an exempt employee.
Right.
There's a test you have to go through and an analysis that you have to go through under the rule, under the Fair Labor Standards Act, to determine if the person truly is an exempt employee.
Yeah, that's great. And I think the other question, and it's probably going to get into the duties test, and I know our hotline can help with that. Your firm can help as well, but is, okay, well, the person gets paid a bonus, a commission. They're below the threshold on a weekly basis, but they do get paid a bonus and or commission. And I think that's where the duty test has some layers of testing to determine, is it discretionary, non-discretionary, the ability to earn it, when to get paid, how much of it is a portion of their salary, lots of different factors. Anything you would add to any of those, to that question about, I get paid a bonus and or commission as part of my job, but my weekly earnings is below that amount, maybe each week.
Yeah, I think you're right, Phil. I think that we really do have to examine the duties test and also sometimes look at the highly compensated employee exemption as well to determine whether that individual is in fact exempt. And I think the point that I'm trying to make is that the Department of Labor and outside legal counsel and AIM, we do take an individualized approach to all of this. Each position does need to be analyzed and evaluated to determine if it truly is exempt or non-exempt. Now, I will share one other thing for you, and this is a great segue or follows in line with your question there, and that is that right now with this proposed rule change, not even proposed rule change anymore, the final rule change, now is a great time to conduct this examination of your exempt, non-exempt status. And if there are changes that need to be made, a lot of times you can do this under the guise of this new rule coming out. If your practices haven't been great up until today, this is a great time to get on board and fix those things, to do an analysis and to make sure that you are properly classifying your employees.
Yeah. All right. We got just a couple questions here. I'm going to get to those, and then we're going to let you get to your programming schedule there, Burt. Let's see. Janine's asking the question, do we need to comply by July 1st for the first step? That answer is yes.
Yeah.
We need to start working on that now. Even if there may be a holdup in court, we don't know that, so we want to be prepared. And the best thing to do there is print a list of everybody who you have marked as salary, not earning overtime, and start the evaluation top to bottom. That's exactly how we do it. Some are really easy to say yes to. They're fine. They're not eligible for overtime, and others are not as easy.
Yeah, and also a follow on to that, Phil. It's a good time to update job descriptions because that's a significant piece of the analysis.
Yeah, that works hand in glove, right? That's one of the first things they're going to do is ask for a job description, and crafting those the right way is sometimes skillful and purposeful, to have the right reflection of the job. And then the second part of this is it lawful to have part-time salaried employees who only work, let's say, 24 hours a week?
It is, and there's a way to handle that properly, but yes, exactly.
Right. Okay, very good. All right, Burt. Hey, we're going to let you go. You've had 277 practice episodes right here on This Week at Work. So you go show them how it's done.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/This Week at Work, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.